Hi guys, welcome to the fifth class of IPC, and today we are going to discuss the topic which is called abatement. This is a very important topic in consideration to your exams and the knowledge of law, and that's why section 107 of IPC is completely dedicated to this. Abatement is also considered as chapter 5 of IPC, and it is, as I said, in section 107. So, abatement, if we discuss, it's generally constituted by three types of activities. Firstly, instigating a person. If you instigate a person to commit an offense, then it is called first type of abatement. Secondly, if you are engaged in a conspiracy to commit the offense, then it is the second type of abatement. And thirdly, if you are intentionally aiding a person, if you are aiding a person to make a crime, then also it is a part of abatement. So abatement, as I said, it's of three types: instigating a person first, then secondly engaging in a conspiracy to make the person to commit it or yourself committing it, or thirdly if you are intentionally aiding a person to commit it. Mind it that for the third category, just aiding is not sufficient to get you hold of abatement. For getting convicted in abatement, there must be an intentional aiding, means voluntary aiding with your knowledge and with your intention. Then it is called intentional aiding. So that's important. So there is a famous case which is Gangula Mohan Reddy versus State of Andhra Pradesh. It is a Supreme Court case of 2010 in Indian jurisdiction. And in that case, it was held that abatement involves first the mental process of instigating, and second, some positive act by accused is essential to constitute abatement. So these two important elements, that the your process of instigating and the positive act in pursuance of that. So these two are important, and that was determined in this case. Now, as we've seen that there are three types of abatement, so we'll discuss all these three one by one. The first is abatement by instigation. So what is instigation? First we should know. Instigation is an act of inciting another to do wrongful act. It is basically inducing a person so that he does something which is a crime or offense. So there are various activities which forms instigation, and those are counseling. If you counsel somebody to do something wrong, suggesting, encouraging, procuring, commanding, urging forward, provoking, inciting, and encouraging. So all these activities, if you do to some person and he commits a crime, then you will be held for the charge of abatement. So this encouragement is a very important constituent out of these all, and this was held in the case of Parimal Chatterjee, 1932. Now, once we have seen that what forms the instigation, now we should also see what is not instigation. So now there are certain categories of activities which are not instigation, and those are mere acquiescence, silence, silent assent basically, verbal permission, advice per se, and not specific advice. So these all are not part of the instigation. Now instigation can be made by various types. These can be willful misrepresentation, or basically the concealment of material fact. If you do so and the person is instigated, that is also equally liable as that of the instigating a person for abatement. And then instigation by letter and a direct instigation. So all these are sort of instigation which are responsible for the abatement. So now the next category, as I said, it is abatement by conspiracy. Now what is conspiracy? First we should see. So as per section 120A of IPC, the criminal conspiracy is an agreement between two or more persons to, number one, do an illegal act. So simply it's an agreement between two or more persons to do an act which is illegal. Also, it could be an agreement between two persons or two or more persons to do an act which is not illegal, but by illegal means. So criminal conspiracy has two elements. One is the illegal act, and one is the act which is not illegal, but if you do it by illegal means, then it is also get hold under criminal conspiracy, which is mentioned in section 120A of IPC. Now for abatement by conspiracy, there are three things. which needs to be satisfied. And those are governed from this the concept of criminal conspiracy only. The first is conspiracy between two or more persons. The presence of two or more than two persons is required. The second element for abatement of conspiracy is act or illegal omission in pursuance of that conspiracy. So there must be an act or illegal omission. And the third essential element for the abatement by conspiracy is that such act or illegal omission must also take place in order to do the things conspired. So the three elements for abatement of conspiracy: conspiracy between two or more persons first, second is act or illegal omission in pursuance of that conspiracy, and the third is the very important is that the act or illegal omission must physically take place. So there are some cases related to abatement of conspiracy from Indian jurisdiction. The one a famous case which is related to abatement of forgery is Pandala Venkataswamy 1881 case. And there is another case which is Haradhan Chakravarti versus Union of India. It's a Supreme Court case of 1990. In that case, it was held that no person can be convicted for conspiracy if the charge against all other conspirators have failed, or if other alleged conspirators are acquitted. So it's related to the group of conspirators, that if somebody is already freed or he's acquitted because of no allegation, or allegation could not prove for conspiracy, the other person who is involved with him has to be definitely released. He cannot be convicted. So this is all about abatement of conspiracy. Now the third type of abatement is abatement by aid, which is mentioned in clause 3 of section 107. Now in that there are certain rules. The first rule is a person cannot be held guilty of aiding the doing of an act when the act has not been done at all. So means the person has aided but the act physically was not done. So he cannot be held guilty for that. The second point is mere giving aid does not prove abatement unless the person providing the aid is aware that an offense was being committed or contemplated. So this is a very important point, that the intention of the person is important. If somebody is just aided the offense but he was not mentally aware that he is aiding the offense, he cannot be held liable. So this was held in the case of Mukherjee J and Ramanath in 1924. So this was a finding in that case. The third important point with abatement of aid is that mere presence does not amount to aiding. If you are present there but you have not done anything, and there is no implication of your legal duty to do or to not do anything, you will not be held liable for aiding. Now aiding has certain category also. Abatement by aid is generally has three categories. One is aid by illegal omission, another is aid by act, and the third is aid by affording facility. Now we'll quickly see all those one by one. The first is aid by illegal omission. So in that there is a famous case which is Khaja Nurul Hussain versus Fabric Tonere. In that case, it was held that it is necessary to show that accused intentionally aided the commission of offense by his non-interference. So if due to the non-interference of a person, the act was aided, so this need to be demonstrated for holding the person for illegal omission. There is another case for illegal omission which is Queen versus Khadim. In that case, it was held that the omission to give information of crime happening does not amount to aiding. So if a person omits or he does not provide an information to the respective authorities that some crime is happening, so he cannot be held liable for that unless such person is having a legal obligation to do so. So if a person is having a legal duty as per his profession to inform, that he cannot absolve his responsibility by not informing. Although a general person, if he has no legal duty to inform, he has the right not to inform, and in that case he will not be held liable for aiding by omission. But if there is a duty, then he has to do so. So this was the finding of the case of Queen versus Khadim. The second category in abatement by aid is aid by act. So there is again a famous case which is Emperor versus Fayaz Hussain. In that case, what happened? The facts are that the Zamindar lented his house to an investigation officer, and he was aware that that officer is going to use that house for torturing a suspected thief. So here he was aware and knowingly he gave his house for a rent. So he was guilty of abatement by act. Now the third category is by affording facility. The typical example here is if a priest he officiates an illegal marriage related to bigamy or any bigamous marriage, and he knows about it and he affords that marriage. So it becomes the case of abetment by aid. So now we will see the next. Now we have discussed all the three categories of abetment. Now we should define who's an abetter. That is also an important question. It can come in a short type answer question. So as per section 108 of IPC, the abetter is a person who abets an offense, and he can abet so by the one who abets either the commissioning of an offense or the commissioning of an act which would be an offense if committed by a person capable by law of committing an offense with the same intention or knowledge as that of abetter. So it has two parts, as I said. The first thing is he abets the commissioning of an offense directly, or he commissions an act, he does an act which becomes an offense if committed by a person capable by law of doing so. So there are certain explanations which are mentioned in section 108 in detail. So if somebody want to read that, that is good enough to read about the abetter. But pertaining to the topic of abetment, this is enough to know that section 108 prescribes certain conditions for the person who abets an offense, and such person is called an abetter. Now, section 117 talks about abating in a public, the offense. So if more than 10 persons are there, then it is called abating in public, abating by public, and the punishment here is 3 years imprisonment or fine or both. While section 118 says that if you conceal the design, then the imprisonment is up to 7 years. So this is all about abatement. You must know what is abatement, which is mentioned in section 107. What are the types? 3 types of abatement, which is abatement by instigation, abatement by conspiracy, and abatement by aiding. So these all case laws we discussed. We discussed what constitutes abatement and what is not considered as abatement. Then we have seen the respective case laws. Then we have seen the section 108, the definition of abetter, and about the punishment of abatement. This is all for preparing about the abatement. However, you know that IPC is a big thing, big subject. It's very descriptive. So I try to conclude what is important. Although I do not deny the possibility or the opportunity you should have to read the complete Indian Penal Code. You should not leave anything. And these are only the points which should be there in your mind with regard to your examination and interviews. Although it's always better to read the complete penal code for the full and comprehensive knowledge that I suggest. So thanks for that. And in the next classes, the upcoming class, we'll discuss about the general exceptions, and the further topics will be taken up in the next classes. Thank you for staying tuned with me. Thanks.